This is attorney Mark Nicholson from Law Office of Mark Nicholson, also known as the Battery Man. And this is day 4 of the Jonathan Majors jury trial. So the prosecutors are alleging, of course, that Mr. Majors battered Grace Jabbari, right? Well, today is the day that she actually testified. And this is what was said in that message in the car that they were in. This private message, it said, "Wish I was kissing you right now." That is what the message said. Wish I was kissing you right now. That is what she was supposed to be. Jabbari was supposed to be upset about. She was shocked at the possibility of some kind of infidelity given the seriousness of this 2-year relationship. That's what she's claiming. She believed that they were headed towards marriage. And she grabbed his phone to see the messages that he received. Then she claims that Mr. Majors grabbed her right hand, twisted her forearm, then struck her right ear to get the phone away from her. She said he ordered her out of the car, and when she tried to leave, she says that she was picked up by Majors and thrown back inside the car. Now, prosecutors showed a video of this moment as well as subsequent surveillance videos showing Majors running down the street with Jabbari chasing him. And she said, "Hey, I was just doing that to kind of get answers about who he was texting." She was frequently asked whether she felt pain. And she said that she felt some pain, but she had a high tolerance for pain because she was a dancer and able to withstand a high level of pain. That's crucial because that's one of the elements they have to prove, is pain. Also, I thought was interesting is that she testified that she did not want to sit home alone or be in the apartment with him. She wanted to go out and party. So she ran into these 3 strangers who apparently witnessed what happened, and they asked her if she could celebrate a birthday at some club because it's supposed to be some friend's birthday. And these are strangers. She explained it by saying that this was the worst thing in my head would have been going back to the empty apartment that we shared. She said that was the worst thing. Now, she also said that she is a dance instructor, and that's kind of where they met on Ant-Man versus Wasp, that movie there. She testified that she felt loved and cared for by Jonathan Majors. But she also detailed several alleged incidents of Majors growing angry with her and yelling at her or withholding affection over incidents including spending time away and not answering her phone when he called. She said he told her she should not share with her things with her family and her friends. That's what she's claiming. Now, I find it interesting that not only did she have to be asked several times about feeling any kind of pain, but also the issue of her saying the worst thing was sitting home alone in an apartment. Well, why? Why isn't going to the hospital since your finger's supposed to be broken? Why isn't calling for 911? Why is she chasing him down the street? I find that to be a very odd scene. And also, she claims that when he tried to get out of the car, she grabbed at his coat. So if he's trying to get out of the car and she's trying to keep him in the car, listen, I think this could be a situation of self-defense. That phone was not her property. So he has a right to defend himself and his property. In Indiana, and in other states as well, you have a right to defend yourself and your property. And she had no business just because she saw some text message saying, "Hey, I wish I was kissing you right now." Didn't give her a right to grab his phone. It's not her property. And if she was that injured, why is she running down the street, chasing after him? So he did run away from her. it is strange to me. She does all this partying and things like that. And then when Jonathan Majors goes to the apartment, he sees her in the closet, on the ground, seeming to be suicidal and things like that. What happened when she was out partying? I mean, was she out with these friends with blood dripping from her head? Was she out drinking and partying with a broken finger? And then maybe she got drunk. Maybe, and the testimony is going to come out that apparently she took some sleeping pills or something like that on her own to go to sleep and not think about it, and passed out and fell out in the bathroom. When she took the sleeping pills, did she end up falling down and busting her head and that kind of stuff? We don't know. She didn't get to finish her testimony today. She'll be called back to the witness stand again tomorrow. But it's going to be interesting when the defense cross-examines her, and I hope that they do a vigorous cross-examination, because there's some things that are just not adding up. And oh yes, and she claims that she's afraid of him. And we hear that, especially as men or African-American men, when it comes to white females that are alleged to be victims, that, oh, I'm scared of him. And it plays sometimes into the racial stereotype that people have of an angry black man, and just angry and violent. And so, although they didn't come out and say it explicitly, that's the undertone that is out there. And it's sometimes good when you're doing voir dire to kind of weed out some of those racial biases and ask questions. Do you think that black people are more violent? Do you think there's a problem with race in America? When I have cases like this, those are some of the things I ask for the jurors, because if they're prejudiced, we try to weed them out. Now, most people won't get in there and say, hey, I'm racist, I'm prejudiced. They don't necessarily say that outright, but you can ask them questions, and sometimes it comes out unintentionally, sometimes intentionally, because they don't want to be on the jury and they just get in there and say it. Now, when the prosecutor is asking direct examination questions, those type of questions, the responses are going to be more favorable to the prosecution. They're open-ended type of questions. These are the type of questions that are going to elicit favorable answers from the witness, because that's what they're doing, asking her questions. It's when she gets cross-examined where the defense can now bust open some of those inconsistencies in the story. And like what I like to do when I cross-examine witnesses, I tell the story. I don't let them get in there and tell the story, because I already know the answer. So here's an example, just a brief example of the type of questions that you could ask during a cross-examination. So then you went to the apartment, and you were alone, and you took medication or sleeping pill, right? And after you took those sleeping pills, you passed out. You fell down. You don't know if you hit your head when you fell down. You don't know if you tried to prevent falling and hit your finger. You got out of the car, and Jonathan Majors was running away from you. He was trying to get away from you because he was afraid of you, and you were pursuing him, trying to reach him, trying to force him to give you answers, right? You tried to get his phone. That phone didn't belong to you. You didn't pay for the phone. That phone wasn't in your name. That phone was Mr. Major's property. He owned that phone. He paid the phone bill. And you believe that you somehow had a right to grab his property, to take his property, to take something that didn't belong to you. We call that theft. Would you agree? So what does she do? She brings up all these past incidents, right, that really can't even prove, to say, hey, he grabbed my stuff and busted my stuff and did all this other kind of stuff. But we're not even here for that. That's not even what the trial's about. It's not about the past stuff. It's about what happened here. But they're going to throw that in there to try to muddy the water, to try to make the jurors say, hey, Now, the judge did admonish them to say this isn't being used to say that this is his propensity to commit these acts, but just to give you some background information. Now, I don't really know how you separate that. You can't unring a bell, so when the jurors hear it, they're obviously going to have a negative inference from it. But this is often what happens in criminal cases. I know when I try those cases, I try a lot of domestic battery cases, why I'm known as the battery man. The prosecutors will try to bring up all these past incidents where no one called the police and all this kind of stuff like that. And it's really, basically it's impossible to prove that it did happen or it didn't happen, but jurors hear that kind of information and they can hold it against your client. It's not fair, but that's what they do. So I'm really interested to see this cross-examination. Hopefully it comes in on Wednesday or maybe Thursday, depending on how many more questions that the prosecution has of this witness. But there's reasonable doubt because, hey, if someone grabs your phone and it's not their property and things like that, she may have been thinking that they were going to get married, but he wasn't thinking about maybe getting married. But still, doesn't give you a right to sit up there and grab that person's phone. So there's definitely some reasonable doubt from the testimony that was given today. And it's going to be interesting to see as the case progresses if those reasonable doubt, those holes in the prosecution case, because apparently there's some holes, if they can get filled in. And if they can't get filled in, if the defense will drive a Mack truck right through those holes. And if those holes are filled in, and even during cross-examination, the defense can't seem to go through those holes or can't break through that wall, they are going to probably have to put their client on the witness stand to get in there and tell his version of what happened. And basically right now, from what I've seen and heard so far, Jonathan Majors should testify if things happen the way he claims they happen. So that's your Nicholson Nugget of the day. If you like it, please like and subscribe.